Good afternoon and welcome to the Law School's celebration of Constitution Day 2023. My name is Andrew Leopold. I'm the Edwin M. Adams Professor here at the College of Law, and it's my pleasure to welcome you to what has become an annual event here at the Law School. It was on September 17th, 236 years ago, that 39 of the 55 delegates to the Constitutional Convention in Philadelphia signed the final draft of the U.S. Constitution, a document that remains one of the most important in world history, and one that, for all its imperfections, still has a lot of wisdom to offer us, if we're willing to hear it, on how we can organize our public lives in ways that create a stronger and more just society. To help us celebrate this achievement, federal law designates September 17th as Constitution and Citizenship Day. And each year, the College of Law hosts a special event on behalf of the University of Illinois at Urbana-Champaign to commemorate the occasion. Our topic today is prosecuting presidents, and we are fortunate to be joined by two distinguished panelists to help lead the discussion. On my left, Roger Heaton, the former United States Attorney for the Central District of Illinois, the Chief Federal Prosecutor in this judicial district. Roger has a long and distinguished career as a federal prosecutor, work that included extensive participation in the investigation of former President Bill Clinton as part of the Whitewater and Monica Lewinsky investigations. Roger has also served as the Director of Public Safety for the state of Illinois and served for a time as Chief of Staff to former Governor Bruce Rauner. Roger has been a great friend to the College of Law, and we are lucky to have him with us today. To my right, Jacqueline Ross, the Prentice Marshall Professor of Law here at the Law School. Her bio says that she is a respected scholar in the fields of evidence and don't let them fool you. Jackie is one of the world's foremost authorities, I'm not exaggerating, on comparative criminal law and criminal procedure. She is the author, co-author, and co-editor of several journals, published many articles, and one of the things that Jackie has highlighted for us here over the years is how much Americans can learn from the comparable experiences in other countries. And as we think about how this country should move forward with presidential investigations and prosecutions, there's no one whose insights I would value more. Jackie has also spent 9 years as an assistant U.S. attorney, federal prosecutor in Chicago and Boston. So thank you, Jackie, for joining us. Here's how I'd like to proceed. After some preliminary remarks, I'd like to ask our panelists some questions about the particular investigations that are going on now, trying to respond to and perhaps answer some of the questions that we might have about what the heck is going on in terms of the investigations of former President Donald Trump. After that, I'd like to invite both Roger and Jackie to talk for a bit about how they think this world where we're quite routinely investigating presidents and other high officials, how that affects not only society, but the presidential elections and our what it tells us about our self-governing abilities. Then I'd like to leave some time for questions at the end to make this, to the extent we can, a discussion. First of all, can everyone hear okay? I'm hearing the fan there. Is there anything we can?
Can you turn up your mic just a little bit? It would be helpful.
No. Oh wait. Is that better?
Yes.
Okay. So we need the mics. Appears to be the message. Now turn it down a little bit.
The overflow as well.
Say again?
With the overflow as well.
Okay. All right. Is this better? All right. I won't move. let's start by setting the stage. But before we begin the discussion, I just want to make clear none of the three of us have any inside information about what's happening with respect to the various investigations and pending criminal trials, right? If we did, we probably couldn't tell you. So this is all based on their experience and, of course, just being generally informed, but no detailed information about the specifics of the case. All right, so let's not worry about it. So there are 4 cases that are currently pending against former President Trump. We'll talk about them in a little bit, one at a time, but just to refresh your memory, there are 2 federal cases and 2 state cases. The 2 federal cases, one of them involves the so-called document mishandling, right? These are the confidential documents that the indictment against the president alleged was kept in Florida, not returned when they should have been returned, tried to be moved and so on, or tried not to be moved and so on. So that's the documents case. The second federal case we might call just an election interference federal case, and that involves the claim against President Trump. I'll call him President Trump just because former is complicated. Against President Trump and only President Trump. He's the only defendant in that second federal case. The most recent of the cases is the Georgia case, at least Georgia for now, the Georgia case that involves a so-called racketeering charge, a RICO charge, where the president and 18, I can't remember if it's 18 or 19 co-defendants are charged in a 41 or 42 count indictment, broad sweeping allegations against all kinds of people, many famous, some you've never heard of. And then the final and the first of the state charges to be filed was in New York State, and that involves altering documents involved with alleged hush money paid to Stormy Daniels to keep information out of the press in connection with the 2020 election. Okay, so 2 state and 2 federal. Some of the times the president is the only defendant or close to only the defendant. Other times he's part of a much broader group. So let's talk about them if we could, perhaps one at a time. Let's start with a classified documents case. And let me start with you if I could, Roger. So the allegation is that when he left the White House, President Trump took with him a series of confidential, top secret, classified documents, brought them with him to his home in Florida, and then when asked, he didn't return them. When the FBI went to get them, the allegations are, he hid them so that they wouldn't discover that he was still in possession of classified documents, which is a violation of federal law. Okay, so the question is for you, let's assume hypothetically that President Trump is not the first high-level official to have mishandled classified documents, that these things happen sometimes. If you're a prosecutor, how do you think about that? When you're looking at the evidence, let's say you're the one that's going to prosecute President Trump on this charge, or might charge him with mishandling the classified information. Does it matter to you that somebody else, President Biden perhaps, also didn't handle classified documents exactly right? How do you think about that?
I think the information that others may have engaged in the same kinds of conduct or related kinds of conduct is certainly relevant to a prosecutor's analysis. But I think that at the first level, the prosecutors are going to want to determine whether they have sufficient evidence that's admissible in court that's going to be persuasive and that they can ultimately be successful with their prosecution. If they get to a point where they have that kind of confidence, that they think this is a case that's going to go forward, then they can make these kind of discretionary judgments about whether this case deserves to be brought and why it's somehow different and appropriate to pursue, even if similar conduct didn't lead to a prosecution in the past. So it's just a question about prosecutorial discretion. I would say that the prosecutors will care about whether they look to be treating people unfairly or disproportionately. But I think that they're going to be more concerned initially about, is this a case that we can actually prove to a jury?
Jackie, any thoughts?
Yes, I think, can you hear me? So I think sometimes when there are violations that occur, well, for example, when somebody who already works for the government takes classified information home, there are other sanctions that are available, such as firing the person, administrative sanctions, but here, so one thing a prosecutor always takes into account is there something short of the criminal sanction that's available as an alternative? Also, was the violation willful or accidental? Was some classified information swept up and among other documents so that the person who took them might not even have realized that he was holding on to classified documents? Or were there efforts to hide the documents, efforts to resist demands by the government to get the documents back? So in the classified documents case, what seems to aggravate it is the obstruction of justice that occurs, or the may not be obstruction of justice if there isn't a criminal investigation, but at any rate, the attempt to hold on to the documents after the government has asked for them back, and not to hold on to them under some claim of right, I declassified them and I have the power to do that, but simply to hide them and to come up with reasons why you can resist returning those documents over. So it's the affirmative attempt to avoid returning the classified documents, to hide them, concealment, lying, that aggravates the underlying offense and is going to make it more likely that a prosecutor will charge the offense. So they want to know, was this accidental, was it willful? And then did the person immediately give the classified documents back? There's also an interesting question about why the person took the classified documents. Sometimes, for example, people take classified documents home because they're working on a case and they're being careless. Sometimes, though, they might take classified documents home because they wish to share them with another government or to auction them off, to derive some sort of profit from them. So the purpose behind the taking of classified documents will enter into the analysis. And not all of that information is necessarily publicly available. There are no doubt all sorts of intercepted conversations that would be available under FISA, that would be intercepted by the CIA, by the NSA, that might shed some light on what the person who took the documents was trying to do with them. But that may not be something that emerges in the public realm because the government may need to protect its sources, including its assets overseas. So the prosecutor may have access to some of that information in deciding whether to charge the case, how serious the violation is, but that doesn't mean that it's going to be disclosed in the indictment.
Okay. The election interference case, right? This is the one arising out of the January 6 events and the president's efforts, alleged efforts, to overturn the election on improper bases. One of the striking things about that federal case, this is the one brought in the District of Columbia, is that the president was the only defendant named, and yet there were 6 unindicted co-conspirators what's an unindicted co-conspirator, and why are they unindicted? If they're a co-conspirator, why don't we thump them?
Sometimes we would like to do that, so that's not an unusual or surprising question. But there are good reasons sometimes not to include someone in an indictment. I don't know in this particular case exactly what Jack Smith and his team were thinking, but I know that you could have concerns about how complex a case would be to present to a jury, and of course the more defendants that you have in the case, the more lawyers you're going to have involved, and the more complicated it becomes to manage all the players. And so it could be that a prosecutor could decide, I'm going to pursue a case that I believe I can prove against a single defendant, and I will have a simpler process to achieve my goal. And there can be time later, perhaps, for a prosecution of others who may have been involved in the crime as well. But importantly, it could also be that the unindicted co-conspirators are being encouraged, let's say, to cooperate against the higher ranking individual, a higher profile target. And so the plan is to get those unindicted co-conspirators to cooperate, perhaps unbeknownst to the person who's been charged, but could be known as well. So it could be that they're already cooperating, these six, some of the six may already be cooperating, or it could be that there's an ongoing effort to coax and persuade them that it's in their best interest to work with the government so that they don't ultimately become an indicted defendant.
Jackie, one of the questions that came up in relation to the Georgia case, the big RICO case, right? 19 defendants and all 40-some counts, goes the other direction. If what you care about is the efforts to overturn the election in Georgia, why are you going after 19 different people? Why don't you just go after the big guy? Doesn't, as Roger was just saying, doesn't the presence of a whole bunch of other defendants enormously complicate your job as a prosecutor?
Well, one thing that the Georgia prosecutor may be worrying about is that the president may, or former president may seek to blame other people, and by presenting these other people as part of a conspiracy with him, it is an effective way of saying that the involvement of other people does not exonerate him. So it's a way of presenting a theory that the other people on whom he was relying are really co-conspirators and not just people whose innocent dupes he was in his decision to contest the election. I also think it is a way of probably of exerting pressure on some of them to cooperate. So sometimes you have unindicted co-conspirators when people are already cooperating. Sometimes you charge somebody when you think you have the evidence, and you also think that they might in the future wish to enter into a plea bargain. And then you think it's important, however, to not present the president as the lone defendant, because otherwise he can always say, well, I wasn't acting alone. So you have to have a theory about why the other people are also guilty. And also, of course, charging many people is a way of getting more evidence in front of the jury. So some evidence is admissible against only some defendants, some evidence is admissible against everybody. So it's a gamble. The downside is the trial is going to be more complex. It may take longer to get to trial. It may not get to trial until after the election. There may be severance, that is, cases may be separated out. But the benefit is you get to present the larger theory of the conspiracy, and you also get to have the jury hear the evidence against all of the defendants and not just against the president. And you also, in that way, foreclose the defense that, well, I was just an innocent person misled by others, if you make that person part of the theory of the case.
Now, this is the second time we've heard that part of the charging decisions that the prosecutors may have, in part of their thinking, may have involved trying to pressure some of the other people in the case. So in the documents case, not only was the president charged, but his valet or his body man or whatever title he is. And Jackie, you just mentioned maybe you charge 19, hoping that some of the I watch Law and Order. I know how this stuff works. Why don't you just give them immunity? I mean, as I understand it, the prosecutor can promise anyone, really, not to prosecute in return for their testimony, and under the federal statute, the person can't refuse, right? And so the question is, why would the government be going to these extraordinary lengths to try to convince Sidney Powell or Ken Chesbrough or one of the unindicted co-conspirators? Why try to persuade them on threat of a charge when you can just force them with immunity? What's wrong with that?
Most prosecutors don't like to grant immunity to witnesses or prospective defendants. They view it as their job to gather evidence and to prosecute people who do things that are wrong, and they're not anxious to just let someone get a pass. They recognize that it's sometimes valuable and necessary because they can't gather enough evidence from inside a particular group that were participating in joint criminal activity without getting an insider's information. So immunity is a necessary tool, but most prosecutors don't like to grant it. There are a variety of ways to try to minimize the consequences, but one of the concerns, frankly, for prosecutors is if I grant immunity to someone, they will be weakened as a witness, they will be damaged as a witness because the cross-examination and the attack on them is going to be to say, you're just saying all of these things because it got you something very valuable. No jail time for you. So they try to avoid it when they can.
So people are more credible if they've been convicted of a crime than if they've been given immunity?
I'd say for the most part that's actually true. If you're going to face consequences for what you did, yes, you're going to get some hope for a break from the judge in sentencing because you did something to cooperate. You're less damaged than if you get a complete pass.
I think in the Georgia case, there's also going to be an issue about whether what is charged is really protected by the First Amendment or whether it's criminal. One of the advantages of having somebody plead guilty to that crime and then cooperate and testify against the former president, about the crime is that in testifying, the cooperating witness acknowledges that the conduct she engaged in was a crime. And that she was willing to plead guilty to that crime. So part of the value of the cooperation is often simply acknowledging, having the jury hear that somebody who was a co-conspirator considered what they were doing illegal and considered what they were doing not just to be an ordinary exercise of First Amendment speech, but that there was subterfuge, that there was dishonesty involved, and if they understood that what they were doing was illegal, then the inference is the other defendants would have understood it as well. And I think that's important when there's a real debate about whether the underlying conduct was illegal.
Jackie, you prosecuted for a long time. One of the peculiarities in the Georgia case is the possibility that this could be moved to federal court. What does that mean? Have you ever seen such a proceeding?
Well, there's often overlapping jurisdiction. The same offense can be prosecuted by the state or can be prosecuted by federal government. Sometimes the federal government waits and sees what happens in the state proceedings because maybe there is jurisdiction over some offenses that are easier to prove in the state proceedings. Sometimes the potential federal prosecution is a second bite at the apple. So if if there's no conviction in the state case, the federal government may decide that there are important federal interests at stake and bring the case as a federal case. But usually there is some sort of coordination between the authorities who discuss between themselves who is going to bring the charges, who has the strongest case.
Roger, did you ever see a case that got
I was
where
never
state
involved.
prosecutors moved to federal court?
Not in this context where we're talking about presidents or political officials. I think Jackie's right that there are a lot of situations where you have essentially concurrent kinds of jurisdiction over or conduct, and the reasons that she pointed out are accurate. I assume, without having personally done it, that in instances like this, the concern is that someone who's engaged in their role as a federal official, doing what they're supposed to do as a federal employee, can't necessarily get a fair shot in state court where they're not as interested in protecting federal interests. And I assume the statute that allowed for removal was designed to keep, the federal interests fully protected, but I'm not sure.
I'm not sure anyone is sure. At least that's what the briefing has suggested so far. All right, last one on the New York documents case. You bring that case, Counselor?
The New York documents case, well, I think that it's going to depend on whether you can identify a class of similar cases that have been prosecuted. It's going to depend on how powerful the evidence is. But it also is going to depend on whether you think that there's going to be some sort of advice of counsel defense. And if so, the prosecutor has to have some theory about why that's not going to be relevant in that particular case.
It does seem like a smaller case than, trying to overturn democracy. Anything we should be thinking about on that one, Roger, on the New York case?
One of my concerns about that case, because it does appear to be weaker to me than the other cases, is whether, if it goes to trial first, I think it's set for trial in February of 24. If it were to go to trial and the former president, were acquitted, I wonder what effect that's going to have on the public's already bipolar reaction to what's going on in all of these cases. I think there's often public messaging consequences to cases that are tried and lead to an acquittal, as to whether the resources and the efforts that are going into all these are well spent. And so I'm pretty concerned about that case. It doesn't look like a slam dunk winner to me. But again, I don't have personal access to all the evidence that they've got to present, and we'll see. To the extent that there's an advice of counsel defense in that case, I guess it would be the advice from Michael Cohen, who is certainly no friend of the former president at this point, and he's got his own problems with his own criminal activity. So I don't like the New York case, and I wish there was a way for it to go last, if not go away.
The good and bad news about the situation we find ourselves in is that we're not alone, and we're not the first country to have faced this. I want to invite Jackie to say a few words, if she would, about what experience other countries have had in investigating, prosecuting presidents, high-level officials, and what we might learn from that.
Well, in Italy, Silvio Berlusconi was charged with multiple serious offenses before, during, and after his term as president, his various terms as president. He was convicted of tax evasion, false accounting, paying bribes to judges, extortion. He was eventually cleared of all of these, but he was cleared in part because while he was president, he had the power through his party in parliament to change the legal system, and he did. He greatly reduced the statute of limitations so that most of his crimes were now outside of the statute of limitations. After he had delayed the prosecution or delayed his defense through various motions, the way in which the Italian statute of limitations works is that it keeps running while the case is pending in court. And so his delay motions eventually drew things out for long enough that he could enact a law shortening the statute of limitations and thereby immunizing himself from these offenses that he was already convicted of. So he was subsequently cleared of these offenses on that basis. He was also cleared of false accounting because while the case was pending, his party redefined the offense of false accounting so as to legalize what he had done. And now under the new law of false accounting, one has to prove harm to an identified victim who wants to come forward and have the case prosecuted. That was not the case in the particular false accounting prosecution that was brought against him, and so he was again cleared because of the retroactive effect of a law that he had passed while he was president. So one of the risks to a legal system in prosecuting a president or former president is that the president may have the power to change the criminal law to protect himself from conviction. Other examples include Lula da Silva, President Lula da Silva, who is now president of Brazil, was president previously, was thereafter convicted of running a vast corruption scheme, but his conviction was subsequently overturned on appeal because a Supreme Court justice found lack of jurisdiction. It was tried in the wrong city. Instead of Brasilia, where he lived, it was tried in a different city, and therefore the case was vacated on grounds of lack of jurisdiction. And while awaiting retrial on these charges, he was elected president. So after his conviction in 2018, he was considered disqualified, but after the jurisdictional argument was accepted by the Supreme Court, he was once again eligible to run and was actually elected. In France, President Sarkozy was prosecuted for using party coffers to conceal excessive campaign spending against campaign finance laws. He was prosecuted for allowing Gaddafi of Libya to finance his campaign illegally. He used a lawyer as an intermediary to contact witnesses in his case by using a burner phone and using a false name. All of this again was proved in court. He also paid off a Supreme Court justice hearing the corruption case against him by promising to recommend him for a lucrative position as an advisor to Monaco. He was convicted of all of these offenses. The conviction was upheld on the first appeal, but a second appeal is pending. So long as that second appeal hasn't been confirmed, he remains free to run again for office and may in fact present himself as a candidate for the next presidential election. Even if he is convicted, it's not clear that it will disqualify him from running again, because that's a case-by-case decision made by the sentencing judge. So even when a conviction is obtained, the fate of that conviction on appeal is often uncertain, and also it's uncertain whether any of this will actually disqualify the candidate from running again.
Thank you, Jackie. I feel so much worse. Roger, you've had some experience in not prosecuting, but in investigating at the time and sitting president. Anything that you recall from those days that might give us some insight into how we ought to be or what's likely to happen now?
I guess one of the things that I like to remind people about these investigations, it's interesting to talk about the legal theories and the nature of the crimes and all of the complex legal issues that can arise, but there are some very mundane resource kinds of issues that come into play that most people don't think about when they're discussing these that are serious. Somebody has to do these investigations. Somebody has to be a member of the prosecution teams that are put together. And those people aren't just sitting around waiting for the next president to need to be investigated. They have other jobs. They're investigating other cases and prosecuting other cases somewhere around the country. So when the need arises to pursue one of these investigations, and through whatever the current form of appointing a special prosecutor, special counsel, an independent counsel, whatever the system is that's in place, that person starts to think about who's going to be on my team, who's going to do this, where am I going to find the prosecutors, where am I going to find the FBI agents who are going to do this work. And the nature of the crimes is typically complicated. It involves records that are spread out into numerous jurisdictions, and so figuring out how you're going to put this team together, how you're going to pay for it, is not all that easy to do. And the example that I guess I can give from back in the 90s when there was an investigation into a number of different things that related to the Clintons is that first Mr. Fisk had been appointed as independent counsel, and he had been a prosecutor in New York. He put together a team that included some of the experienced and capable people that he knew of from earlier parts of his career. The investigation extended over a number of years. These people have lives, they have families, they have other reasons that they can participate for a while, but not for 3, 5, 7 years. And so over time, you've got to figure out, where do I get these people? And if they're in a current position in a U.S. Attorney's office or in an FBI field office somewhere, and they're going to be brought to the location where this investigation is occurring on some kind of a temporary detail, you've got the people left in that office who are saying, well, who's going to do all the work that they were doing? And so this has a ripple effect, and it's actually pretty complicated to manage over a period of years. And by the time the investigation gets to a point where indictments are brought and trials are going to occur, you have personnel changes and expense issues, and the public is getting tired of, why are we spending these tens of millions of dollars on this investigation? We're not getting anything out of it. And so I just like to remind people that to the extent that you care about and want these investigations to occur, just keep in mind that there's a very complicated process needed to get the resources in place to make it happen.
Despite these problems, are we in a perennial investigative phase in this country? Are we just going to be investigating whoever's in office all the time for everything? And if so, should we do something different than what we're doing now?
Well, I think there's always a risk of process being politicized. On the other hand, one of the strengths of our system is that we have multiple jurisdictions that can ensure some independence from whoever is in power, and that's a strength not to be taken for granted. So the state cases are not cases in which a president can pardon himself. The president can't give instructions to prosecutors in the state cases and can't influence the federal officers in our system to the extent that some other legal systems allow. So in France, there was actually wrangling about whether you would have an independent investigative body capable of bringing investigations of corrupt political figures. In France, the most complicated types of cases are investigated by investigative judges. And investigative judges are independent of the Ministry of Justice. So the Ministry of Justice can't tell them to drop a case if it's politically inconvenient. The Ministry of Justice can do that in case of other cases that are brought by prosecutors. So the Ministry of Justice has hierarchical control over prosecutors, not over investigative judges. When Sarkozy was president, And even before that, while he was Interior Minister, he actually tried to do away with the institution of the investigative judge. And the main argument that was made against this reform that he had proposed was that it would do away with the judicial independence that was needed to investigate corruption. So I think while there's always a risk that one can have perennial prosecutions, I think it's also a strength of the system that it does allow enough independence for prosecutors or investigative judges, for independent investigators of some sort, to act as a check on power.
Independent counsels, does that do it for us?
You know, the first special prosecutor was, I think, appointed back by President Grant in 1875. So we've been at this for a while. We haven't been able to figure out exactly who the appointing person or entity should be and how to get the independence that Jackie talked about that we desire, and to keep that independence and yet have some control. We don't really want to create a fourth branch of government. We got to put it somewhere. Who should have the ability to control it? Should it be the judiciary? That's what the case was back in the Independent Counsel Act days. But that has separation of powers issues as well. We tend to think of it being an executive branch function, and yet we're talking about investigating presidents, and we want the independence. So I don't know what the answer is going to be. I think we're going to continue to grapple with this. And even though we get weary at times of these investigations and the problems that they create, we also are reminded of how offensive it is to us every time somebody decides to engage in self-dealing and take the property or the other power that they're not really entitled to and abuse it. So I don't see this going away, and I don't know what the answer is. Maybe there isn't a single answer. Maybe we have to try something for a while until we just can't stand the consequences anymore, and we'll shift to a slightly different model. I mean, right now, where the Attorney General has the ability to give power to a special prosecutor and leave that special prosecutor free to make the decisions about what resources they need and how they're going to apply them and what cases they're going to bring, it's still subject to the criticism that, you know, the Attorney General is involved in motivated to select people and to constrain the resources in ways that would change the outcome of the investigation. I don't know what the ultimate answer is going to be. I do think that it needs to be predominantly in the executive branch for most of these cases, I think.
Finally, before we start taking some questions for either one of you, any prediction what's going to happen over the next year, 18 months? What's the effect going to be of having these cases pending on the election, on the voting? What do you think?
Well, I think with that many cases going on at the same time, it's unlikely that any of them will actually proceed to trial before the elections. And if any of them does, I think it's probably the New York case, which is the weakest of the four.
Your prediction is, putting the New York case aside, none are going to go to a jury verdict before the election?
I think there are so many ways for a defense to draw out the process through motions and through claims that they're simultaneously preparing multiple cases that I think it would be very difficult to actually get the case to trial, even to begin trial before the election.
So New York aside, you're predicting a period of nomination, electioneering, and the actual election within the shadow of indictments, but no convictions? But no resolution, I should say.
I think there's a real chance of that, yes.
Do you agree with that, Roger?
I'll start with the Georgia case. Not a chance that sees a courtroom for a trial in 2024. Not a chance. Way too complicated. The federal January 6th case also could be complicated. I don't know. I've heard that there are over 10 million pages of discovery in that case, and with the 6 unindicted co-conspirators and not knowing what they had to say, that's a defense lawyer's dream, I think, to try to look for different ways to create delay. So she's probably right about that too. My only hope, and I'd like to see one of these cases go to trial before the election, my only hope is the classified documents case. So I haven't given up on that one. March, April 24 trial date right now. But by then you've had Super Tuesday, you've had the nomination process take place, so I'm not sure whether it will be in time to make any difference there. So I think she's probably right. The New York case has a chance to go. I don't know what's going to come out of that case, but I'm still hoping for the classified documents case.
To the extent CNN is correct, they were saying this morning that Alvin Bragg and the judge in that case have agreed to postpone.
We have late breaking news. Say that again.
So
CNN is reporting
that Alvin Bragg, the prosecutor, and the judge in the New York case have agreed to postpone until at least one of the federal cases is. So
CNN is reporting that the New York prosecutor and the New York judge have agreed to postpone the New York case until after there is a judgment in one of the
I don't think they said until when, just that they're gonna hold until.
We're in no rush.
Indeed.
Yeah. Wow. So maybe none, right? Get resolved. Thank you, Janice. That's yeah. Even
I
what
don't know what any other network is saying.
it'll probably be different by the time we wrap up here. Floor is open for questions. If you have, and if you wouldn't mind coming to the podium, maybe I can hear you and I can repeat it. Yeah, go ahead.
Watching television yesterday, I may have the terms inaccurately. They were in the Georgia courtroom, and there were 2 of those 19 co-conspirators. Their legal counsels were arguing some mundane cases about jurisdiction, but it seemed to me they were getting close to some kind of an indictment and moving forward. Perhaps I'm incorrect.
I'm not 100% sure because things have changed so we're talking about the Georgia case, and there was supposed to be a hearing this morning. A couple of the defendants in the Georgia case were resisting the move from state court, which is where it was filed, to federal court under this procedure we were talking about earlier. The trial judge said, no, we're not going to allow you to move. Let me say this right. We are not going to have the case removed because what you were doing was not part of your official duties. You were not acting as a federal official when you're doing this. You were acting as a campaign person. So right now, the case is staying in Georgia. There was supposed to be a hearing this morning on whether there would be a stay of that order. And the last thing I heard was that that's been withdrawn because they're talking about going to trial on at least 2 of the Georgia 19 in Georgia court soon. I mean,
Those 2 insisted on their speedy trial.
they wanted their speedy trial right, which gives you a fixed number of days within which the trial has to start. So I suppose there's a chance. Talked about it as the 4 cases. Do they, are they resolved or not? I suppose what we really care about is whether they're resolved against the former president.
Right.
But it is possible that there will be some co-defendants against whom the cases will be resolved before the main event. So I think that's what was happening there. But like I say, I didn't check my news feed this morning, so maybe it's more than 4 cases we're talking. I don't know. Yeah.
to Jackie's point that having multiple jurisdictions is a positive thing. In 1973 and I believe 2000, Justice Departments under two different presidents declared that you can't indict a sitting president because it would just be too distracting. Now, you've got literally thousands of district attorneys. If they go chasing around people in government on, what we're dealing with here are cases of first impression, looking out for, wouldn't that make it, for the same argument used in those DOJ memos,
Yeah.
that make it very difficult for them to conduct their business.
Yeah. So the question, and correct me if I'm not paraphrasing this correctly, the comment was multi-jurisdictions are good because it helps diffuse power. On the other hand, if what you're worried about is interfering with the operation of the presidency and the executive branch and the election, right, that there have been Justice Department memos saying you can't indict a sitting president. Part of the reason for that may be because there are 51 jurisdictions plus the federal government, and if all it takes is the filing of a charge, and that's permitted, right, the perennial investigation of president, that could really interfere either with the president's carrying out of his duties if he's sitting, or could interfere with the election, right? One of the things that I'm concerned about with all these cases pending is, as I was saying to Roger earlier, that it will suck all the oxygen out of the news cycle, right? That everything in the election cycle will be about the trials and what was testified about today, assuming that if they're ongoing. And then candidates who might actually have a thought about running, governing, stuff like that, their views will be hard to hear if it's all criminal cases all the time. So yeah, the interference with the process, whether it's the presidency itself or the election process, is potentially not a small cost. Mr. Lawless.
I suggest it'd be interesting to hear both Professor Ross and Mr. Eaton's thoughts on the professional ethical obligations of the attorneys in these cases, both prosecution and defense.
The professional and ethical obligations of prosecutors and defense attorneys in this case.
All of them.
I think the attorneys should be ethical.
Jackie, you dissent?
I think I can go with that. No, but I think that there are particular challenges to prosecuting a president. You have to be seen to be even-handed in the application of the law, to be applying the law to the president the same as you would to other defendants. One of the ways in which, of course, it changes the process too is that our process is so reliant on plea bargaining that I think prosecutors are just not used to prosecuting cases in which it's clear from the outset that the case is going to go to trial. I'm being somewhat facetious here. There are cases that go to trial and about which one knows from the beginning that they will. But I think the obligations are essentially the same as it would be in most cases, to make sure that you've got enough evidence to warrant the prosecution, and to make sure that when you make cooperation arrangements with other defendants who might testify, that the terms under which they testify, whatever benefits they might be offered, are fully disclosed. But I think the challenges there are pretty much the same obligations that apply across the board.
You might have noticed that some of the defendants in these cases are attorneys. And it's not uncommon in multi-defendant cases for the attorneys who represent each of the different defendants to enter into joint defense agreements where there is information sharing that goes on in an effort to allow each of them to represent their client to the best of their ability. And so all of the communications that are going to take place between these defense attorneys who might be in these joint defense agreements are somewhat risky if any of the conversations steer into territory where there could be an allegation that the attorneys are somehow crossing lines and doing things that could be designed to obstruct justice in the pending cases. So when I jokingly talk about the attorneys being ethical, I think it's really important for all of you who are attorneys or plan to be attorneys to recognize that when you take the oath and when you commit yourself to doing these things, it's very possible that you're going to be in situations like some of these lawyers will be, where they have to really think about what can and can't be done, what really is ethical representation of your client, and what's crossing a line and what could put you in the crosshairs where you could end up being a target of an investigation.
I think we have time for one more. Janice, you?
So the former president has allegedly violated the terms of his pretrial release bond on multiple occasions. I wonder if you could talk about the challenge in Georgia of the court enforcing those terms?
The question is, it has been alleged that the president has violated the term of his pretrial release in Georgia. And now what? I take to be your question. What's Georgia going to do about it?
Well, in a sense, that's the big question about the prosecution too, if he's convicted, or is he gonna go to jail in Georgia? Yes, so I think, in a sense, this is a preview of the bigger issue. Can Georgia enforce its laws against a president or former president? And they certainly can make the motion to revoke bond if the violation is egregious enough and if it's clear that it's willful, that he's continuing to do it, as in a sense challenging them to revoke his bond. The risk of doing so is that if the judge doesn't do so, it may already be a kind of public relations victory for him that announces that he can get away with violating the terms of his bond. So potentially, yes, a prosecutor can move to revoke. A judge might be willing to do so, but if the judge isn't willing to do so, then that really does raise a question to what extent Georgia is going to be able to enforce its laws against the former president.
What's the Secret Service going to do if he's put back in custody? I mean, their job is to protect him, not to protect others, to protect him. And are they going to be present in the Georgia Fulton County Jail? Is he going to have a cell or a cell block that's essentially segregation because they can't put him with other inmates? It's very complicated to figure out how you would actually put a former president in custody, and I don't know what the answer is.
Not just former president, right? But he is running for reelection, and if you're correct that the Georgia proceeding won't occur until after the election, well, let's not go there. Thank you all. We're at the time. Please join me in thanking Roger Mead and Jack Ross.